A very good day to you. Welcome to Herman Manyora's channel from wherever you're watching us from, Kenya, East Africa, Africa, or any part of the world. My name is Jadiel, Kabiro. I'm joined by Herman Manyora for today's political conversation. It's a big day, Prof. A big day. BBI.
BBI.
Gone.
Gone as in?
Is it gone now, completely, based on Supreme Court's
Someday,
finding?
one day. That's what Uhuru Kenyatta said. And Raila said BBI is on just half-time. And that's exactly what has been confirmed today.
The Supreme Court has put it that they did not follow the right procedures, the BBI, terming it unconstitutional. Currently, right now, Deputy President William Ruto's team is celebrating.
How would he be celebrating? What is he celebrating?
That BBI is gone. Should he be celebrating?
That's what agenda half-time you celebrate. This is just half-time.
Why would you say it's half-time? Because now we cannot implement the Building Bridges initiative maybe until the elections are done.
The people who didn't want BBI would have been happy if the courts today had affirmed the decision of the High Court and the Court of Appeal. Namely, that the people of this country cannot change their constitution.
Okay.
Yes.
So right now that
wasn't the case.
The basic structure doctrine was...
that is the only thing that was up for determination today. There was nothing else.
Even who initiated it, President Uhuru Kenyatta.
Those are small matters.
Now, when you look at the basic structure doctrine, does this mean that later in the future, as you're saying, we're going to see BBI back and that the Court of Appeal messed us up thinking that we cannot change the constitutional with eternal clauses?
It was a waste of valuable time for Kenyans. Yeah, because you see, the BBI thing is something that is from the handshake. And Uhuru and Raila wanted to cure some of the problems that afflict this country, over which people lose life senselessly in every election year. Property is lost, in which we lose billions of shillings, sometimes even in every day. So we were trying to cure that, and that opportunity was squandered by the High Court and the Court of Appeal, basically.
Right now,
because if they had just said there are some things here that are not constitutional, go back to the drawing board, rectify them, the referendum would have been done a long time ago.
Does this mean that you're happy with the ruling that was made by the Supreme Court, the way it was delivered, how CJ Martha Koome and her bench delivered it?
Yeah, that's how I go. That's what I like. I like when I listen to Njoki Ndongo and I listen to Martha Koome. And I said, this is how a court ought to deliver judgment and any ruling. In a simple, straightforward case. I said these things so many times, and the people hit at me. I said, you must just isolate the issues. What are the issues? It begins simple with the fact that you cannot stop Kenyans from amending their constitution, which is what the High Court was saying, which is the Court of Appeal was saying, which was wrong. It was as simple as that. And it has taken just simple English from CJ Martha Koome to tell Kenyans that, look here, there is no other way of looking at this thing.
She said we must look at our history so that we not bring foreign stuff in.
Yeah, it is a simple thing.
Look at what she said. She said that the most important thing is for there to be a balance of rigidity and flexibility in the constitution.
Yes.
How can we create this balance?
It's already been created. We come from a past where our constitution was so mutilated there was no way they two look the same. The constitution we had before just around 2010 and the constitution of independence time, 1960-63 there. They were different documents. It had been changed and completely discolored and disfigured and mutilated. So we said, we cannot allow this. We cannot allow this. One of the changes was to turn Kenya from a multi-party democracy to a de jure one-party system. You could not have a political party. And it was done one afternoon.
Yeah.
Mwai Kibaki and Charles Njonjo, just like that, I think in a day or so, one afternoon. So we say, no, we can't allow that. But at the same time, we said, it will be foolish to have a constitution you can't change. Because it's a living document. Times change, things change. What we think are so important to us may not be important to you people young tomorrow. And so even you, some of the things you think will be a matter of death to your children will be rubbish. So to that extent we say We cannot allow people to mess with our constitution in the manner in which Kenyatta 1 and Moi messed with our constitution. But we also said, hey, hold on. Let's not use our past to enslave ourselves. Okay?
Yeah.
Let's also be free enough to be able to change our constitution. So that is a balance that Chapter 16 kind of gives you.
Would you agree then with Ruto's allies who are coming and saying, even if we have said that our constitution is not, it doesn't, the basic structure doctrine doesn't apply to us, later on in the future, we need to look into it and apply it in Kenya? Would you agree to that?
It's a very difficult question to answer. All I know, we should have learned from this BBI, that although there are safeguards which have been affirmed today by the Supreme Court, there is need to look more. Are those safeguards enough? Are they really enough? Perhaps they are not enough.
Okay.
Now that we know, they may not be enough. So, I don't know who will come first. The person who will come and bring back the BBI referendum, or the person who will come with a new safeguard. I don't know who will come first.
Okay.
But both of them will come, certainly. If Raila gets the presidency and they implement the BBI thing, the other people should come and introduce more safeguards so that in the future, we don't allow people a field day.
Okay.
Yeah.
Look at the finding, though. The president shouldn't initiate the Building Bridges initiative. It should go through the popular initiative way or through parliament. When you look at this finding, we have Justice Njoki Ndung'u coming and saying the president did not initiate it, and even if he did, it is not wrong for him to do so because he's democratically a Kenyan. And then we have CJ Martha Koome coming out and saying he initiated it. It is wrong. Now, this question of interpretation, Kenyans are getting confused. How can we deal with it?
You know, sometimes when you listen to learned men and women and educated Kenyans, you wonder, how can they fail to see simple things like this? The popular initiative is not so much who initiates. It is a pathway. It's a pathway open. Look here. The Constitution says this. You people have elected members of parliament. They will do things like amending the Constitution from time to time. Some of the amendment, of course, may come back to you in a way of referendum. But supposing you want to amend the Constitution, you approach your member of parliament, he doesn't listen. Are you locked out? No. Popular initiative is a path to anybody. And Njoki Ndung'u correctly put popular by way of numbers. The 1 million signature, the 25% of the blah, 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 majority in the referendum. That is what is popular about it. But to me, I see it as a pathway. Because why I'm saying that I can sense a lot of cheapness on the part of people who are saying the president shouldn't is, if it is a question of the president, why can't he just say, Manyora, do it for me? So you look at how cheap it is.
So
it is so cheap. But these other things, the president cannot do anything about them. The process, he can't just change it. But in terms of a document to be given to Manyora to move around with.
So you find Justice Njoki Ndung'u,
she's the one who makes sense.
Saying numbers instead of who.
And it's not who, it's a pathway open for you to change anybody. And the numbers, the popular part of it is the numbers. The people you must convince for this thing to see light of day. Those are the numbers. That's what is popular about it. The other change is in parliament. You convince fellow parliamentarian and everything passes. And the only thing is it touches on those protected areas in 255(1, then it goes for referendum. And that people engage with it only at that level of the referendum. But even then, we are saying there's still something popular about it.
Okay, Justice Lenaola called it absurd, what the route through the president initiating it. We saw Justice Ouko also saying you cannot run with the hare and hunt with the hounds.
Yes.
What would you say has led to this situation? Someone was saying the Attorney General should be forced to resign because of this situation. He should have interpreted that this is how things would have gone.
No, you can't. This is an opinion. 7 men and women today were giving an opinion that is quite different from what the other 7 plus 5, 12 judges.
Yeah. With the basic...
A judgment or a ruling is an opinion. Yes. That's why whenever there's a higher court, you can get different opinion. How can you fault the Attorney General? But I would fault the Attorney General because some of these simple things he should have seen.
Which simple things?
There are so many simple things. Hiccups. Some of them appearing in this case, some not. Like who was the promoter? Juneta and Dennis Waweru came in rather too late. Okay?
Yeah.
Although Njoki Ndung'u showed that really that is not the case. She showed that the document from the steering committee and the document Juneta and Waweru presented to IBC had major differences.
Yeah.
So, but a much more careful Attorney General would have known that. A much more careful Attorney General will have prosecuted some of the issues in a much better way and earlier. A much more careful Attorney General would have looked at the composition of the High Court judge bench and pointed out certain people ought not to have been on that bench.
Oh.
Some of them were the judges President Uhuru Kenyatta had refused to appoint.
Yes.
And they were on that bench. Why didn't the Attorney General point out that and argue that they ought not to be on that bench? So there are many things the Attorney General Charles Kihara is a rather dull Attorney General. I wouldn't keep him as my age.
So
not for a day, not even for an hour.
You'd agree that he should resign now?
Yeah, he should just go home.
When you look at
not because of this BBI. This BBI is a big score to the Uhuru and the Raila. Yeah, so why would he resign?
We'll talk about that political angle later. But when you look at the second schedule, speaking about the introduction of the 70 constituencies, this is actually one of the two things that let the BBI go down. Would you say it's a big loss to Kenyans? Because as you look at the Azimio side, they're saying during their campaigns, we're talking about introduction of constituencies that would be beneficial in terms of bringing CDF down to the people. When you look at it now, would you say Kenyans have lost because of BBI and this part of the second schedule?
No, to the extent that no referendum is being done today, one would hope that by the time there's a referendum on the cards, they will have sorted out this issue of constituencies in a manner that will not offend the opinion of the Supreme Court and of the other judges. If you asked me, there's nothing serious about what they were saying.
Nothing when it comes to second schedule.
Nothing. And these things have been prosecuting them very well in media and elsewhere, because the work of the IBC as protected for that kind of independence is in doing what they are doing. But the argument could also be raised as that independence can be suspended or can even be removed completely through a referendum.
Okay. Simple as that. So when you listen to someone like Kithure Kindiki now speaking about president's immunity, just today, immediately after the ruling was made by the Supreme Court, saying that we will hold them accountable. People that use monies of the government, PSS, CSS, that pushed this drive. How would you say this would turn out politically for both DP Ruto and Azimio's side?
To the handshake brothers, you have wasted our 4 years as a nation. You have wasted our money as taxpayers of Kenya in an illegal process. Now we want to tell you that it is not enough that your illegal decision has been nullified. That is not enough. We are going to hold you accountable for the misuse of public funds. And I want to announce to the civil servants who have authorized illegally and unconstitutionally for the expenditures under the BBI illegal process that Article 226, Part 5 of the Constitution requires that a public officer who authorizes the use of public funds against the provisions of the law and the Constitution should be held personally responsible, whether they are in office or out of office. Kwa hivyo nyinyi watu ambao mko kwa maserikali, nyinyi ma-PSS, nyinyi ma-CSS, mumetumika na wale matapeli wa handshake kuvunja sheria ya Kenya, kutumia pesa ya umma nje ya katiba. Sasa ni jukumu lenu kujitayarisha kurejesha pesa ambayo imetumiwa kinyume na sheria na kinyume na katiba.
These are coming from petty people. Those are petty things. It's not a litigation you can pursue. First of all, you must know, ultimately this thing can only point to Uhuru Kenyatta. We agree?
Yeah.
The president.
Yeah.
It's the president who initiated the whole thing.
Yeah.
And therefore, all expenditure must be traced to that.
Yeah.
Okay? There is no way anybody that released state funds, we don't know how much, could have refused to release the funds if he's directly asked to do so by the president in a manner that I'm sure is not in violation of the laws. Okay?
Yeah.
So then you'll have to sue the president. And now you argue, and it has been proved today, you cannot sue him while in office. So when do you sue him?
After he leaves office.
Now listen carefully. It is agreed almost everywhere that the moment you touch a retired president, you will offend very many people and very many sensitivities. It's very difficult to go after a retired president unless he was engaged in atrocities. In other words, you are going to look bad yourself. Chiloba, one of those names, some short man from Zambia,
Yeah.
even was haunting KK, Kenneth Kaunda, former president of Zambia,
Yes.
and even calling him a non-Zambian, that he was not even a Zambian. Look at that. And people told me you are stupid. You cannot follow President Kibaki where he is and try to harass him.
Yeah.
People will beat you up. You cannot follow Uhuru in Ishaweri and tell him that you spend some 200 million. People think you are mad. So these people must stop cheapness.
Cheapness from
This is cheapness.
What does this mean for Azimio's side right now? The plot was, if BBI sails through, they will be able to negotiate well when it comes to the Prime Minister's position, Deputy Prime Minister's position from their side. What does this mean for them?
You know, you must ask yourself, what is the best that could have happened that would please Raila and Uhuru today?
Yeah.
So then somebody will argue the BBI would have been resurrected.
Yeah.
The Supreme Court will have quashed the findings of the High Court and the Court of Appeal, and the reg are allowed to continue.
Yes.
Fine. And that's why the other side is celebrating.
Yeah.
So then ask yourself, if that were the case, would we have had a referendum between now and the election?
Not really. No.
Would we have had?
No.
When would we have had most likely?
Post-elections.
Post-election. The ruling today or the judgment today, what does it indicate will happen?
That's
The referendum will take place
later.
later.
Yeah.
So,
So it's basically telling Raila supporters that later on,
whether they allowed, they disallowed all this, they allowed all the 7 grounds of appeal, or allowed 5 as they did today and disallowed 2. There's no way you could hold a referendum today before the elections.
so it's just about right now DP's side getting bragging rights.
The bragging again is to show either you are just like a child excited after seeing a lollipop, because at the core of this judgment today was whether or not there can be a referendum to change the constitution. That is all. There was nothing else. The question was, can we as Kenyans or can't we change our constitution through a referendum?
Okay.
The answer was clear today. Yes, you can go ahead and change your constitution.
So the ruling was on the doctrine of
Yes,
basic
yes, there was
structure,
nothing else. All
nothing
these
else.
are other side issues. There's nothing. There wasn't anything else. But for posterity, there was the question of whether you could sue the president. That has nothing to do with
the BBI.
the BBI. But it was an important question for determination.
Okay.
But all the others, they are neither here nor there.
So take home for you, there is no winner, there is no loser.
I think the winner is is Wanjiko. So the people of Kenya, to me, I was very sad actually that the High Court and the Court of Appeal, made of learned men and women, could in their right mind tell Kenyans, you cannot amend this constitution. I was very worried.
Okay.
But today, I'm a happy man, and so are many Kenyans, I think, that we can and we will amend our constitution following the laid down procedures as provided for and as enshrined in our constitution.
You see,
That is,
even Musalia Mudavadi has said the same thing.
They have said-
that it's a win for the people.
It's a win
because
for the
the Supreme Court has overturned.
it's a win for the
but
people.
I think from his side,
but by a win for the people, different people mean different things.
yeah.
So some people,
absolutely.
you see, those who are celebrating, I ask them,
Yeah.
you've been talking about mutilating the constitution and celebrating the High Court and the Court of Appeal. What is there to celebrate in this one? Because you are saying the constitution is protected, nobody can play around with it.
Yeah.
But the Supreme Court has told you, Kenyans will change their constitution. So what are you celebrating about now?
Oh. What should we expect in the near future now? Should we expect things go back?
If Raila wins, you can be sure in the first 90 days, the move to change the constitution will have kicked off. And the latest by February, March, the constitution will be... Because they are going to move to the... If they have advisors, if they have,
Advisors.
they are going to move to the Supreme Court for advice.
Okay.
Following this judgment, will we start the process again, or do we simply expunge the things you have found unconstitutional from our bill and then proceed with our bill?
Okay.
Or, at the very least, do we need to do another set of signatures? But even if they don't go to the Supreme Court, with all the state infrastructure and everything, what's so difficult getting signatures in less than a month's time?
Okay.
Is there any problem?
No problem.
So they will have come up with a new bill, avoid the pitfalls that were identified by the
take you
Supreme
to
Court.
initiate the process.
Yeah, who to initiate? They should give it to Manyora.
Yes.
Not even because if you give it to Junet Mohammed,
Yeah.
somebody else will say, and this is why these guys don't think. You give it to Junet Mohammed, some say parliamentarians have their own avenue in parliament, so this is unconstitutional.
Okay.
They should give it to me.
Okay, Omtato.
Or Okia Mtata and Manyora. We take it.
Yeah.
Eh?
It's that simple for
It's
you.
so simple.
Going back to court, getting interpretation
And that's where we come back to Attorney General. Let me tell you,
as we wind up.
as you wonder, one of the problems I've identified in this country is our reliance on lawyers. When you have a process, especially of a legal nature, that involves some law a bit, we pump lawyers there. Big mistake. Because there's no room for thinking outside the box. You need to have people like Manyora there sitting and telling lawyers, how about that?
Okay.
Lawyers don't think the law. Lawyers interpret the law. Lawyers draft the law. Lawyers don't make the law.
Yeah.
So I have always argued, if you have something as big as this, hold a conference with the lawyers, with whatever they are coming up with. Let other people be there to listen. They are in a room. We listen to them making their presentation. And we tell them things. The things we will tell them are the same things that will be raised in litigations tomorrow.
Okay.
You get what I'm saying?
Yeah. Simple and clear.
That is.
Well, thank you so much for tuning into today's political conversation, a critical analysis of the Building Bridges Initiative ruling by the Supreme Court. We keep it simple, we keep it truthful, and yes, we keep it unbiased. Until we do have these conversations again, have yourself a lovely rest of your day.